just as an example, this idea that the Supreme Court is the only folks that get to decide what the law is a very new notion in our nation's history. It's really about as old as the 1950s in Brown versus Board of Education, where the Supreme Court started to assert itself as the body that gets to only decide what the law is.
That was the Warren Court, if I'm not mistaken, correct?
That was the Warren Court. And there were reasons why they did that and why a lot of folks fell in the line. You had a South that was kind of resisting the times, resisting the fact that our nation was pluralistic. Our people are different multicultural backgrounds, and they really kind of had to lay down the law, and the federal government had to get behind them to enforce voting rights, to enforce desegregation and all of those things. And so a lot of pieces came into play that allowed the court to kind of take this foundational, we are the only ones that decide the law. But prior to that, it's been a competing notion that each of the branches of government have their own perspective on what the law is, and we have a fight over it, or a dialectic or a process. And the Supreme Court itself, from the start, the Supreme Court was definitely kind of the more bottom branch of government, certainly not totally co-equal by any stretch of the imagination.